Hello everyone, this is the first class of constitutional law. In this lecture, we will discuss salient features of the constitution. Okay, let us begin. So in this lecture, we will basically be discussing these topics. Firstly, we will discuss what is the constitution and what is constitutionalism. After that, we will discuss briefly the inspirations for the Indian constitution, where all we have picked different parts from. All of this you will also be reading in your polity syllabus, etc. So we will only skim through it. Then we come to the preamble, whether or not preamble is a part of the constitution or not, and the importance of the preamble for the constitution. Then we will discuss the union and its territories and the law regarding amendment of those territories, alteration of boundaries, etc. Then we will discuss federalism. What is federalism? How is it applicable to India? And what are the exceptions that India has allowed for itself? Then we come to secularism. Secularism, we will only discuss the concept of secularism and how it has been applied in India. We will not be discussing the parts of secularism individually, because that we shall cover when we discuss Article 25 to 28 in the fundamental rights portion. Okay. And lastly, we will discuss what are constitutional conventions and what is constitutional morality. All right. So let us begin. Firstly, what is a constitution? Okay. So in this entire syllabus, since we will be discussing constitutional law, we should know what is a constitution first. The best definition that exists out there is by this American scholar called Bernard Shorts. Okay. In 1950, he wrote a book called in 1950, he wrote this book called Introduction to American Constitutional Law, in which Shorts defined, Shorts is basically what is referred to as, if you read various articles, especially Harvard Law Review, etc. So he is referred to generally as Shorts. Okay. Constitution is a written organic document under which governmental powers are both conferred and circumscribed. Okay. So this is what he defines it. We will also discuss the one exception to it. Okay. Constitution is a written organic document. Okay. Now there is one country which does not accept this definition, that is Britain. Britain says that they have an unwritten constitution, because although they have all structures of government such as the legislature, the executive and the judiciary, however they do not have their functions defined anywhere in a written format. Okay, so Britain has an unwritten constitution. In America, they criticize the British system and say that that is merely tradition, that ultimately Britain is very susceptible to any form of revolution or any such tyrannical power. But Britain says that no, we have a constitution, it's just never been written down particularly. Okay, so the first part is written. Second part is organic. Okay, so organic by its definition means evolving, changing as per the time. Okay, that it grows. So there has to be growth. This is also an ideological view, because in America there is a debate between originalism and living tree. Alright. So originalism is a philosophy that says that the constitution should be interpreted in the way it was originally intended. Okay. For example, if right to equality meant something at the time of being written down by the original founders of the constitution, then it should only be interpreted that way. We should not add new meanings to the word equality as the times change. This is called originalism. And Justice Scalia of the US Supreme Court was one of the prime proponents in the modern era, but there were many other judges who supported this idea of originalism. Okay. Then we come to the living tree doctrine. Living tree doctrine says that the constitution itself is a document that will grow, that will branch out as per time. That if we make it stuck in the era in which it was written down, then it is bound to fail. So the originalists say that as per times, the constitution should be amended. Okay, it should not be static, but it should be amended as per the time, so that it reflects the need of the people. But until unless it is amended, you should interpret it the way it was supposed to be. On the other hand, the living tree doctrine says that not everything will ever be amended, that it needs to be organically interpreted by the judiciary to mean the different things that different times demand. So originalism basically puts the onus on the elected representatives that when times change, you should amend the constitution. Whereas the living tree doctrine says that the judiciary itself will interpret the definitions very differently. For example, when the constitution was enacted, even in India, the section 377 of the IPC that criminalized homosexual behavior, okay, if 377 of IPC homosexuality ban करता था. Now, when Article 21 was originally written, homosexuality was not decriminalized. It was not intended that you will simply allow homosexuality just because there is a right to life. But as times changed, there is more awareness in society now about the LGBTQ movement, etc. So after that, the Supreme Court ended up allowing LGBTQ in the Navteej Johar case. So that is how times change, the mindsets of the people change. Not everything will be enacted into a law, but some things have to just happen through an organic way of judicial interpretation. So this is called the living tree doctrine. We will see how both of these apply in India. Okay, but shortly, in India we follow the living tree doctrine. We don't follow the originalist doctrine. All right. So constitution is a written organic document under which governmental powers are both conferred and circumscribed. Okay, conferred means given by the constitution, circumscribed means limited by the constitution. So the constitution is the source of government's power, the written source of government's power. It lays down what all does the government have the power to authority to do and what does the government not have any authority to do. Okay. So similarly in India, in Keshwanand Bharti versus State of Kerala, the largest ever bench that has ever been constituted, a 13 judge bench was constituted in this case in 1973. Shelat and Grover justices, okay, they wrote a concurring opinion. Whenever we see that two judges or multiple judges write an opinion together, we write JJ in front of the collective names. Okay, I will not write Shelat J and Grover J when they have a joint opinion, because if I write this, then it will mean Shelat J gave one opinion and Grover J gave another opinion. When I write JJ, it means joint judges. Okay. So please keep in mind all of these things, because across this entire course we will be using these same terminologies while discussing the opinions of judges. Okay, and opinions of judges will be the most important part in most of the constitutional law interpretation. So in Keshwanand Bharti case, Shilatin Grover J said, Constitution is an organic document that must grow and take stock of socio-economic problems. Alright, we will discuss the context of the Keshwanand Bharti case when we discuss the basic structure, doctrine and amendment of the Constitution. But effectively, in Keshwanand Bharti case, the living tree doctrine was endorsed, that Constitution is an organic document and it must grow and take stock of new problems. There is no other alternative itself. Okay. Now, what is constitutionalism? Another American scholar, Andrew Haywood, describes constitutionalism as the practices that reflect the desire to protect liberty through internal as well as external checks and balances. Okay. Checks on government power. Internal checks on government power means within government itself, and external checks mean judiciary and legislature. In America, there is a very strict separation of powers. So the legislature and the executive are not at all related. Alright. The legislature in India, for example, we see that ministers are a part of the parliament also, and they have to answer in parliament. In America, there is no such case. So which is why internal means within the government, you need to have different independent organs. Or the bureaucracy. But basically, it means that people themselves should also limit the use of tyrannical power, because otherwise, if you don't check government power, you will reach absolute tyranny. What is stopping a government from becoming a dictatorship, right? Ultimately, that there is some checks and balances that the judiciary, that the legislature will involve, but ultimately it is the government itself that has to limit down its use of excessive power, because otherwise there is nothing stopping the government. So protection of liberty is the objective, because government has the power to restrict the liberty of its citizens through internal and external checks. So that is what constitutionalism is basically about. Okay. Now, negative constitutionalism is to prevent excess, invasion or restriction on liberty. Okay. Negative constitutionalism means that the government should not do anything to curtail the rights of people. They should allow people to be free, to exercise free speech, to exercise their right to life. They should not arrest people arbitrarily. They should not restrict freedom of religion very unnecessarily. Okay, so this is negative constitutionalism, that there needs to be a restriction on the government's power to restrict rights. Okay, that should be limited. Positive constitutionalism is promotion of welfare. Promotion of welfare is also one part. So the government needs to empower its citizens needs to empower citizens to become more free by granting them education, healthcare, a place to live, good nutritious food, etc. People become more free because if you are a healthier individual, you have more opportunities. If you are more educated, you have more opportunities. So ultimately, positive constitutionalism means having this welfare objective as a government in your heart, that you can give people more freedom. So negative constitutionalism means don't restrict their existing freedom, and positive constitutionalism means give them more freedom. Okay, constitutionalism ultimately is about liberty of the people. All right, there are political theory parts to it, that there comes a social contract and there are authors of it, but the questions that we will see in the PYQ discussion, you will realize that they never ask extremely abstract questions. So you will never get the opportunity of going so much into depth about why we need liberty in the first place. All right. Although we will have a discussion on it when we discuss Article 19, but for the time being, this much is enough when we discuss constitutionalism. All right. Now there is a quote by Fali Sam Nariman. Fali Nariman is a major senior advocate at the Supreme Court of India, but he is one of the most celebrated constitutional jurists of the 20th century and the 21st century up till now. So, and he is also the father of the retired Justice Rohinton Nariman. Alright. So, he has written in his book, You Must Know Your Constitution. A constitution does not survive on its contents. It is the spirit of constitutionalism amongst the representatives of people which keeps it alive and functioning. Alright. Because you will see that when the constitution was formed, it was formed in a very bulky manner. It is till date the lengthiest constitution that is written down. In fact, Sir Ivor Jennings was a British constitutional expert and historian. Prior to the drafting of the constitution, prior to the formation of the Constituent Assembly, it was initially suggested that Sir Ivor Jennings should be drafting the Indian Constitution because he is such a great expert at constitutions. That was shot down. We formed an individual, framed an independent Constituent Assembly. Ultimately, we made Dr. Ambedkar the chairperson of the drafting committee, and the entire process happened with the help of Indians alone. And Ivor Jennings ended up criticizing the Indian Constitution a lot. He said that the Indian Constitution is extremely bulky, very technical, will not survive. It takes up too many different aspects. It tries to balance too many conflicting interests in a very narrow sense. There is going to be a lot of arbitrary power. So there were a lot of criticisms that Ivor Jennings gave for the Indian Constitution. Simultaneously, Sir Ivor Jennings was also then appointed to draft the Sri Lankan Constitution. Okay. In India, we still have the same constitution. 73 years have passed. Sri Lanka's constitution lasted 14 years. So ultimately, it is India who succeeded despite all the criticisms, despite nobody believing at the time that India would be able to succeed in this constitution drafting and constitutionalism process. It was ultimately the spirit of constitutionalism amongst the representatives of the people which kept it alive. Okay, throughout the history of Indian constitutionalism, the independent history of India, ultimately the people have always believed that we need to represent the people. There have been instances of autocracy, etc. And it is likely that over time they may happen again. But regardless of it, people have respected the constitution, and that is why we survive as a democracy. In fact, one more interesting tidbit that in the last 75 years, for all the countries that were decolonized after the Second World War, only 7 countries have maintained their constitution, okay, and have had democracy alive for the entire period. The 7 countries are Jamaica, Belize, Solomon Islands, Vanuatu, Mauritius, and Papua New Guinea, and India. So all of these are island countries. Most of them don't have the population which a single city in India might have. Even a tier 2 city in India will have more population than the entire population of these countries. But regardless of it, India has survived as the only major democracy in the post-colonial world. So that is the constitutionalism of the representatives of the people that has ultimately survived, that has helped it gain this much legitimacy in the eyes of the people. Today we are not scared that the constitution will completely be erased off immediately, and that is only because we have a tradition of constitutionalism. Alright. Now we look at the inspirations for the constitution. The Constituent Assembly sat for approximately 2 years, from 1946 December to January 1950. Approximately 3 years, more than 3 years passed to prepare this constitution. And initially there were 389 members. After partition happened, some members left for Pakistan, and at the end there were 299 members in the Constituent Assembly. There were 7 people in the drafting committee. All of these details are just for your knowledge. You will never get the opportunity to write so much in a paper. Alright. And Sir B.N. Rao, Benegal Narsingh Rao, was the constitutional advisor, and Dr. Ambedkar, Dr. B.R. Ambedkar, was the chairperson of the drafting committee. Across multiple topics that we will be discussing, Dr. Ambedkar's views are one of the final nails in the coffin. Alright. And if you go through the Constituent Assembly debates at times, there are multiple amendments which will be discussed. Many people raise their opinions, etc., etc. And finally, the last word is by Dr. Ambedkar, that listen, I think this should happen, or I don't think this should happen. And as a ultimately, almost always, whatever Dr. Ambedkar voted on was the final call of the entire assembly as well, which is why his views we will be discussing separately on many topics, because those were effectively the most authoritative views that the Constituent Assembly saw. Alright. So we will just briefly discuss whatever. The Government of India Act of 1935 was the parent act that laid down the structure of government. So the federal scheme, the office of the governor, that they are being head of state executive, the structure of judiciary, public service commissions, UPSC, state public service commissions, emergency provisions, 352, 356 and 360, and administrative details such as transaction of business rules, etc. All of these come from the Government of India Act. The next most important is the US Constitution. The fact that we have a written constitution, because Britain never had a written constitution. Impeachment of the president, we will discuss this in the next class on president. The functions of president and vice president, the removal of Supreme Court and High Court judges, fundamental rights. This itself comes from the US Constitution. Then judicial review and independence of judiciary. We will discuss all of this in multiple classes. Independence of judiciary, preamble of the Constitution. Preamble we will discuss right next after this. And vice president as the ex officio chairperson of the Rajya Sabha. In the US, it's called Senate. Then from UK, we took nominal head being the president. In UK, they have the crown as the nominal head. The Westminster style of parliamentary system. Westminster Abbey is the road on which the UK Parliament is based. So they have a bicameral house, they have a Speaker of the House, and all other such positions. All of these traditions, including those of parliamentary privileges, and the fact that ministers, which are the executive, are part of parliamentarian, are part of the parliament. All of these are taken from the Westminster style of government. Okay, and we come to the writs. We will discuss writs when we come to jurisdiction of Supreme Court and High Court in later classes. But the 5 writs of habeas corpus, certiorari, prohibition, mandamus, and quo warranto. All of these 5 writs are taken from the United Kingdom. All right. Then we come to the USSR Constitution. Remember, there is something to learn from everything, and we picked up lessons from everywhere. So, the concept of fundamental duties in Article 51A was taken from the USSR Constitution later on, not in the first draft of the Constitution. The idea of justice, social, economic, and political in the preamble was taken from USSR, because justice is not just getting your rights, justice is getting a good economic status, justice is the absence of social discrimination. These aspects came into light only because the USSR was very staunchly a Marxist country and wanted equality as its fundamental concept. Then from Australia we have borrowed from Australia and Canada, we have basically borrowed the federal scheme that we have. Okay, the concurrent list under the 7th schedule of the Constitution comes from Australia. Joint sitting of the 2 houses comes from Australia, and freedom of trade and commerce. Okay, in our Constitution, the restriction of freedom of trade and commerce can only be by law made by Parliament. It cannot be by any other measure. So these measures are taken from Australia. From Japan, we have taken the term procedure established by law. Alright. In US, the right to life cannot be taken without the due process of law. And there was a lot of debate in those initial times because in US, the Supreme Court had interpreted due process to mean a lot of restrictions on government. So our Constituent Assembly was afraid that if such an interpretation is borrowed into India, that will create a lot of hurdles for the government, and especially a very new government, a very nascent government, they might not be able to handle so much pressure. So that is why the due process clause was taken out and the word procedure established by law was brought in. So that was borrowed from Japan. Alright. Then we come to Canada. Once again, our primary federal structure has been borrowed from Canada. Okay, the federalism with a stronger center. There are more powers in the list with center. The distribution of powers between central government and state government, that both can exercise mutually each other's functions in the absence of a law, or if a law grants each other the power. So that is taken from Canada. Residuary powers vest with the center is taken from Canada, because in the US there is only delimitation of the union powers. Okay, there is only one list that what all can the union government do. Everything else, all residuary powers in the US rest with the states. And in India, we decided to go with the Canadian model and we took residuary powers with the center. The center appoints the governors at the state level so that there is some form of checks and balance. The governors in US, the governor of a state is elected by the people of that state itself. So that is not the system in India. The advisory jurisdiction of the Supreme Court, we will discuss in the Supreme Court lecture. Then we come to France. So the concept of republic, that there will be no monarch. Okay. The idea of a republic itself came from the French Republic, the French Revolution, where they deposed the king, Louis XVI, in order to establish the republic, that there will be no dynastic head, that every person will come from the people, every head of state. So this idea of republic was very important because we also wanted to replace the crown and we did not want to replace the crown with more monarchs anymore. The basic concepts of liberty, equality and fraternity mentioned in the preamble, they come from the idea of the French Revolution, liberté, égalité, fraternité. So directly copied from those ideas. Briefly, from South Africa, we have taken the method of election of members of Rajya Sabha and amendment of the constitution, that there are different standards for different parts. Okay. Then we come to Ireland. From Ireland, we have taken the concept of directive principles of state policy, which are mentioned in part 4, that there are some parts which are fundamental to governance, but they are not justiciable. Alright, we will discuss this in the coming classes. The method of election of the president, that all elected members across provinces as well as the center continue to vote. And the idea of nominating members to Rajya Sabha by the president, that also comes from the Irish constitution. The idea of DPSPs, directive principles, was taken by Ireland from the Spanish constitution. We took it in the way Ireland had imagined. So there was a criticism at times in the Constituent Assembly itself that, listen, this is such a borrowed constitution, that everything you have taken from here and there. So how is this an Indian document? And Dr. Ambedkar ultimately replied that constitution drafting has happened so many times in the world before India got the chance to draft its own constitution, that a lot of countries have had experiences. Okay, and governance happens similarly across the world, especially in democratic countries. It happens in the more or less in a very similar fashion. So why not learn from those experiences? And he said, to ensure that we miss out none of the best practices across the world, we have ransacked every single constitution that exists, and we have taken out what was appropriate for India and modified everything that could be applied to India according to Indian circumstances. So there are many innovations despite this, that so many functions that we have borrowed, there are still many things that we have continued in our own way. For example, we have scheduled areas. Schedules 5 and 6 give tribal autonomy to various regions. Tribals in certain northeastern states get rights under Schedule 6 areas, and all other areas get rights under, tribal areas gets rights under Schedule 5. Then we have official languages, scheduled languages. So all of these are things that India innovated on its own, and ultimately as a consequence we took out the best practices from the entire world, applied them to Indian circumstances, and whatever did not still apply, we ended up creating our own innovations. As a consequence, we have a constitution that has lasted for so long. All right. Now we come to the first part of the constitution, the preamble. So the preamble was based on the objectives resolution in the Constituent Assembly. Okay. The first day of the constitution, basically, the first session of the constitution was boycotted by the Muslim League because they were demanding a separate state of Pakistan. Now, because they were demanding a separate state of Pakistan, not much debate or discussion on the nature of the constitution could happen. As a consequence, the Constituent Assembly met only to discuss what will be granting to the people as a whole. And Pandit Jawaharlal Nehru moved the first objectives resolution that basically granted multiple portions that ultimately formed the basis of the preamble ultimately. Okay. Now, what are the functions of the preamble? There are four major functions. Okay. The first one is that it defines the source of authority of the constitution. Who is drafting this constitution? Who is giving this constitution? Who has made this constitution? So, the very first words of the constitution, the first three words of the preamble lay down the source of authority. We, the people. So, that is the source of the constitution, that it comes from the people. It does not come from a monarch. It does not come from a colonial power. It does not come from the Queen or the Secretary of State or Churchill or anyone. It comes from we the people. That it's a part of the independent nation's first endeavor to create a constitution. And the last word is we the people, after so and so, give to ourselves this constitution. Ultimately, it is we, the people, who have created this constitution for ourselves. Okay. The second part is the nature of the polity. India shall be a sovereign, socialist, secular, democratic republic. These two words, socialist and secular, were added in the 42nd Amendment. So the initial draft said sovereign democratic republic. Later on, it became sovereign socialist secular democratic republic. All right. We will discuss socialist when we come to the part on directive principles and fundamental rights, and we will discuss secular in today's class. The first part, the introductory part, and mostly when we discuss freedom of religion and fundamental rights. Okay. Democratic means free and fair elections. Ultimately, a government which is made out of participative politics, where people have the right to express their opinions. And republic, basically the head of state will not be dynastic, okay, will not be hereditary or a birth based position. It will always be an appointment to a post. Okay, so both the president, which is a nominal head of state, is elected in a manner, we will discuss it in the next class, but it is elected by the parliamentarians and the legislators, and the prime minister as well as chief ministers at different levels are also appointed through the parliament, but based on elections by the people. So we are a sovereign democratic republic. Sovereign means we are no longer a colony. We are an independent nation capable of taking our own decisions. Then comes the commitments to citizens. Okay, that there shall be justice, social, economic, political. There shall be liberty of five kinds. There shall be equality of status and opportunity, and there shall be fraternity. All right, so that these are the commitments to the citizens, that this is what we want to grant to the people. And lastly is the date of adoption, that on 26th November 1949 this constitution was adopted. It was enacted on 26th January 1950 because earlier, many years later, about 21 years ago, prior to this date of enaction, the Purna Swaraj Declaration, the Lahore Declaration, was made on 26th January. So we wanted to celebrate that day as the day on which we enacted this constitution. Okay. So this is what the functions of the preamble are. But then a question came, is preamble a part of the constitution or not? Because if it is a part of the constitution, what is its role in the constitution? Can it be amended? Is it subject to the same parts as the constitution, etc., etc., the same restrictions as the constitution? Can the judiciary interpret the preamble at all? So all of these questions kept arising. So the first case where this question arose was because sovereignty and integrity of the nation is a part, right? So in the Berubari Union case, where India had to cede a part of its territory to Pakistan, East Pakistan, which is now Bangladesh, because there were multiple enclaves within India, and we will discuss this in the coming lectures. But this question arose, can preamble be a part of the constitution? In this case, Gajendra Gatkar, who was the then Chief Justice, he said not a part. Okay, he said that preamble is not a restriction on any of the government's powers, but to cede, we will discuss, to cede you need a constitutional amendment. But in the Berubari Union, preamble is not a part of constitution. Then in Golaknath versus State of Punjab, the judge there, Subbarao J, he was a J then because he was merely a judge. He rose to the position of Chief Justice later on. Okay. So he said, preamble contains, in a nutshell, the objectives sought to be achieved by the constitution. Okay. Basically, Justice Subbarao said that preamble is a summary of the constitution, that it contains in a nutshell the objectives that the constitution wants to achieve. Then ultimately in Keshwanand Bharti versus State of Kerala, when they were discussing what is the power of the parliament to amend different parts of the constitution, can they amend fundamental rights, can they impose fetters on fundamental rights, can they amend the preamble, etc., etc. This question came, and authoritatively Justice Sikri ordered that preamble is part of the constitution and it can be amended. Only after this the 42nd amendment came, and Justice Jagmohan Reddy, he said that while defining what is the basic structure, he basically said basic structure can be derived from the preamble. Okay, so he gave it this much importance that whatever is ultimately given in the preamble is basically what the basic structure is supposed to be. That you cannot amend the sovereign part, the democratic part, the republic part, all of these are non-negotiable because they are mentioned in the preamble itself. Ultimately, the last most authoritative case that clearly gave an answer, because Keshwanand Bharti was not discussing whether preamble can be truly amended, this was just one opinion. The case of Charan Lal Sahu versus Union of India, this was asked the same question. So it interpreted the case of Keshwanand Bharti and said preamble is a valuable aid in interpretation of the constitution. It occupies same position as any other part. Okay, so basically the parliament has unrestricted authority to amend the preamble as well, subject to the basic structure, but basically the preamble has no special privileged position compared to the other parts of the constitution. All right. So this was the preamble, that ultimately the final decision is that preamble is a part of the constitution. Its purpose is that the judiciary can use the words in the preamble to aid and interpret what the other provisions of the constitution mean, and it can be amended as per the will of the parliament. Okay. Now we come to the next part, the union and its territory. Article 1, Clause 1 says India, that is Bharat, shall be a union of states. Okay, we will discuss what it means in the coming few slides, but basically that we shall be a union of states. Article 1, Clause 3 says that territory of India shall comprise the states, union territories and other territories that are acquired. Basically, that more territories can be acquired over time. It is not that if this was India at one point, that this is all that India shall be later on as well. Because also it was hoped that later in the future partition may be annulled, or more countries such as the neighboring region might want to join India. So to keep this option open, we wrote this part that other territories that may be acquired. Okay. Article 2 then says Parliament may admit new states on terms that it thinks fit. Okay, on terms and conditions that it thinks fit. Now, much later on, in the 1970s, we ended up acquiring Sikkim. Sikkim signed the accession agreement. Initially, it became an associate state. So this was challenged, and later on other provisions of the article 371F, which was granted to Sikkim to give them special powers, that was also challenged, that how can you grant so many separate powers to one state which are not provided to other states. So in R.C. Podial versus Union of India, Sikkim's article 371F was challenged. The Supreme Court said that not only 371F is valid, but the granting of associate state is also valid, because the parliament has near unfettered authority to grant to admit states on terms that it thinks fit. It may not be on the same terms that every other state has been admitted. That there can be variations depending upon the political conditions in the particular case. So, for example, in RC Podial, Sikkim, the state of Sikkim provides certain reservations to some communities and some Buddhist communities, etc., which are not provided for in the rest of the country. Okay, it has a major Buddhist population, and it came from a very different political tradition, that it was ruled by a monarch called the Chogyal, and etc. Now, and it has a major Nepali population, a Nepali speaking population. So this gentleman was a Nepali speaking Sikkimese citizen, and he challenged this provision that how can you give certain reservations to communities which are not provided for in the rest of the constitution, that this will be unconstitutional. The Supreme Court said that the parliament has this authority to grant reservations, to grant states the power to provide reservations to different communities according to their individual circumstances as well. That this comes within the power of Article 2 to make these. Okay. Now, the third part is Article 3, which says formation of new states or altering areas or boundaries or the names. For example, we change the name of Orissa to Odisha. They will happen by a law of parliament. Okay, they cannot happen without a law of parliament, but this will not happen by a constitutional amendment. This will not happen by an executive order. This will happen by law. Okay. Now, there is a proviso that the bill can only be introduced in the parliament after the views of the state have been taken. It cannot be introduced prior to the introduction, prior to the views of the state assembly being incorporated into these. Okay. The bill, basically whatever is introduced by the parliament, please read the provision, has to be introduced after the state legislature has expressed opinions. Now, this has also been a part of multiple challenges. For example, first time in Babulal Parathe versus State of Bombay in 1960, and this came up. The State of Bombay was expanded to include earlier in 1956 when the State Reorganization Act happened. The State of Bombay was supposed to be divided into Gujarat, Bombay UT, Bombay Union Territory, and rest of Maharashtra. Okay. Now, the opinions of the Bombay Legislative Council, Bombay Legislative Assembly, was taken for this bill of splitting into three. Ultimately, some portions of Maharashtra, the new state, the Hyderabad portion which was taken after police action, etc., all of these were incorporated within the state of Bombay itself. There was no separate state of Gujarat, there was no separate Bombay Union Territory, etc., etc. So that was opposed by this gentleman, that how can you not ask for the opinions of the state assembly upon the bill if because there was no opinion for the amended portion of the bill. Okay, the first bill for which the opinion was sought was one bill, and then the bill that was ultimately introduced in parliament for voting was another bill altogether. So this was challenged, and the Supreme Court held that you do not have the state legislature does not have the right to give its opinions on amendments also. Okay, the state legislature only has the power and only has the right to express its opinions once, and after that it is the parliament's call. They do not need to consistently, repeatedly keep consulting the state on every single amendment that is proposed. It is only when the bill is introduced for the first time that it should be after the opinion of the bill is taken. In Pradeep Chaudhary versus Union of India, the question was that in the bifurcation of Uttar Pradesh into Uttarakhand and Uttar Pradesh, the entire city of Haridwar, the entire district of Haridwar, or only the city of Haridwar should go to the Uttarakhand government. Okay, the initial bill that was presented to the state asked for the Haridwar city only. The ultimate bifurcation gave rights to the entire Haridwar district. The Supreme Court only reiterated the decision in Babulal Parathe that the opinions every time need not matter, that the parliament's call is supreme, that it is within the parliament's power to decide. Okay. Then we come to the issue of Mulla Periyar Environment Protection Forum versus Union of India. So in this case, the bifurcation of state gives certain powers which were overriding the state government's legislative powers. Okay, the bifurcation of water subjects, etc. Water is a state subject. So when Travancore, etc., all of these states were being merged into Kerala, and portions of Tamil Nadu, Kerala, etc., were being delineated, then the state made the Union of India in the bifurcation bill gave certain powers to the state of Kerala, which were challenged. That how can the parliament amend these powers? Okay, the parliament gave certain rights to each state, etc., etc., which they could not or should not have because it was not within the legislative competence of the union. Water is a state subject. The Supreme Court said parliamentary law under Article 3 overrides the legislative competence and of Article 246. Okay, so Article 3 takes a superior role as compared to merely the division of lists within Article 246. The last case is Mangal Singh versus Union of India. In this case, the Parliament also has the power to amend in Article 4 of the Constitution. The Parliament can lay down how much the legislature strength, etc., of every state is going to be. So, in Mangal Singh versus Union of India, the rights of the Punjab Assembly, because their legislature strength was slightly less than the minimum threshold, alright. So they said, how can the parliament do this? The Supreme Court said those are indicative, but Article 4 gives nearly unfettered power to the parliament to decide based on what is appropriate. Alright. Now, admission of territory, alteration of boundaries is done. Now we come to cession of territory. Okay, cession you will study properly in international law, but cession basically means giving away territory to another nation. Okay, you cede territory. Cede is the word CEDE, and its object form is the word cession. Okay, so when you give any territory to another sovereign nation, that is called cession. Now, for the first time this question arose, it was in the Berubari Union. Berubari Union was an enclave on the India-Bangladesh border. Back then it was with East Pakistan. Now, it was more difficult for India to access the Berubari Union than for Bangladesh, and so India just wanted to give it away. That why bother with so much? So they just signed an agreement and gave it. The Supreme Court said, no, you cannot do that. You can't simply give it away. The power to admit new states does not give you the power to also alter the boundary of the nation itself. Okay. For that, you need to have a constitutional amendment. Whenever I write CA, I do not mean chartered accountant. Please be cautious. I will always mean constitutional amendment when I write CA. Okay. Throughout the entire constitutional law portion, CA will only mean constitutional amendment. So there is a need for a constitutional amendment to cede territory. This is not within the power of Article 3. Okay. Right after this, the 9th constitutional amendment was passed to give away this Berubari Union to East Pakistan. But after that, there was a certain village, there were certain areas within them which needed clarification, because it was unclear whether they will also be going to East Pakistan or whether they will stay. So in Ram Kishore Sen versus Union of India, the 9th constitutional amendment was challenged that you cannot give away these villages, you need a separate amendment. The Supreme Court said no, the Parliament has the power to decide what is the interpretation of that the areas mentioned in the constitutional amendment. Okay. So there is no need for a separate amendment. It will only be clarified by the government whenever they do it. And the last one was in 1990 for the lease of the Teen Biga corridor. Okay. For a very long time, because there were a lot of Bangladeshi enclaves within the Indian territory also, and it was only in the 100th amendment ultimately in 2015 that the exchange of enclaves was completed with Bangladesh. Prior to that, the entire border of Bangladesh, this is India, this is Bhutan, but so there were multiple enclaves in this region in multiple parts, especially in the Cooch Behar region of Assam, which had enclaves of Bangladesh. So the people there could not be Bangladeshi citizens completely because they did not have access to Bangladesh borders, and they were still citizens of Bangladesh. As a consequence, there was a Teen Biga corridor which was leased to Bangladesh, so that there is a corridor which connects them with the people of with the boundaries of India, so that people can move through into their country. Now the Supreme Court said that this lease of Teen Biga corridor does not mean cession of territory. Okay, so this is not cession. A lease is only a lease. We are not parting with the sovereignty. So there is no need for constitutional amendment. This can happen without any constitutional amendment also. Okay. Now we come to this main part, federalism. There are two main kinds of systems that prevail in the world wherever there is a constitutional democracy or any constitutional system: unitary and federal. Okay, unitary is basically where there is, as the word itself says, one system. So UK, Japan, etc., all of these major countries which do not have different levels of government exercising different powers independently, they are called unitary systems. Okay, China is also a unitary system, although it is not a democracy at all. So these are unitary systems. Then we have federal systems. Federal systems normally have division between center and state level. Okay, we will discuss in the coming slides what are the components of federalism, because what is federalism itself has been debated after the Indian Constitution was passed, because people were like, ये federal है कि नहीं है, मतलब हमें कैसे पता ठीक से. So now the debate is settled. Whether or not Indian Constitution is a federal one was in question for a very long time. It also has implications on the constitutional scheme of how what are the rights of states. because the constitution does not mention the word federal. Okay. Now that debate is settled that federalism is a part of the basic structure, okay, is a basic feature of the constitution. This was settled in the SR Bommai case. Okay. After this case, it was laid down that India is a federal country and federalism is a part of the basic feature. We come to the question, what is federalism? Okay. There are two distinct nature of questions that you can expect. First is, what are the features of federalism? The second part will be, is India a federal country? Okay, or what are the unique features of Indian federalism, etc. Discuss both of them separately. Okay, first understand what is federalism and then discuss whether India is a federal country according to those definitions. Alright, so we will be discussing different measures, the different definitions that various jurists have given. This will allow for a better understanding that who calls India a federal country, who does not call India a federal country. Alright. So the first definition that we look at is Professor MP Singh. Okay, Professor MP Singh in the Oxford Handbook. Oxford Handbook of Indian Constitution. Professor MP Singh is also the author of one of the most authoritative books on constitutional law. Okay, the Introduction to the Indian Constitution, and therefore he holds a lot of authority on when he says something, it can directly be quoted in a paper and it will fetch you a lot of brownie points. So he gives a fourfold division of what is federalism. First is that it is a system of division of powers at two or more levels, primarily two levels. Okay, a central government and a regional government. Is India federal according to this definition? Yes. Okay, we have Article 246 which defines the legislative division of powers, and then we have Part 11, the administrative divisions from Article 256 onwards for administrative powers. So all of these are India is a federal country according to the first system. The second part is division of organs, legislature, executive and judiciary and finances at different levels. Is India a federal country according to this? Yes. There is a legislature at the state level, there is executive as well as judiciary at the state level. Okay. For example, in Japan, there is executive at multiple levels, but there is only one legislature. Right. As a consequence, the executive has to follow the law made by the center. It is a unitary nation. India is a federal nation according to this because the state government has legislature, executive and judiciary. So the first point was division of powers. The second part was division of organs. The third part is supremacy of the constitution. Is India a federal country? Yes. Why? Because constitution is supreme. For example, in Israel is not a federal country, it is a unitary country. There the parliament is the constituent assembly also. That the parliament can change any part of the constitution at their will, and consequently they do not have a basic structure doctrine, they do not have any protection. Recently there were protests in Israel because the new Israeli government wanted to change or limit the powers of the judiciary very drastically, and because they do not have a basic structure doctrine, the Israeli constitution can directly be amended by the parliament itself. Okay, there is no supremacy of the constitution, there is supremacy of the parliament. Even in Britain follows the principle of parliamentary sovereignty, parliamentary supremacy. Okay, where whatever the parliament says, the judiciary cannot overrule. The judiciary can only interpret the laws made by parliament, but the judiciary cannot declare any particular law made by the parliament to be unconstitutional. They can only say that they can only express an opinion that listen, we think that these portions can violate other parts of the unwritten constitution, but otherwise the judiciary cannot strike down laws. In India, judiciary has very explicit powers in Article 13 that because parliament cannot make a law that violates fundamental rights, the judiciary has the power to nullify those laws. In Britain or in Israel, there is no such power. Okay, the law made by the parliament in both of these countries is supreme. So in India, we follow constitutional supremacy. And the fourth part is dispute resolution. That whenever two or more organs of the levels of the government are in dispute, is there a mechanism to resolve that dispute? Here also, yes, India is a federal country because the original jurisdiction of the Supreme Court, we will discuss it when we discuss jurisdiction of courts, but the original jurisdiction of Supreme Court is about resolving center state disputes. Okay, either a dispute between two states or a dispute between center and states or a dispute between center and some states on one side and more states on other side. Okay, all of these are covered within the original jurisdiction on the Supreme Court. So whenever there is a dispute, parties can go to the Supreme Court and claim a remedy. Now the nature of federalism in our constitution is slightly dicey. Okay, the word has not been used in our constitution. There is no such mention. The preamble, for example, says sovereign, socialist, secular, democratic republic. It does not say federal anywhere. That is because the origin of the word federal comes from the word fidus. Okay. Now fidus in Latin means agreement or treaty. Alright. Now what are the other federal countries in the world? There is United States of America. It is not called America, it is called the United States of America. Because the states initially, when USA got independence from Britain, there were 13 colonies of USA which became states. State itself initially meant a sovereign nation, and then they entered into an agreement to form this United States of America. Right? As a consequence, this federal nation was born. Similarly, we have Switzerland. So in Switzerland, there are different cantonments. These cantonments are almost sovereign. In fact, Switzerland does not even have one president. It has 7 presidents, 7 councillors. They keep rotating as with the designation of president amongst themselves, and they only handle very minor functions. The majority of the functions are handled by these cantonments, these municipal boards themselves. So including citizenship, besides the citizenship of Switzerland, you also need citizenship of every cantonment board where you want to live. Otherwise, you can't live there as a citizen of that cantonment. So that is because these countries, these units were sovereign once upon a time, and they entered into an agreement. And that is why when we had this chance of calling India federal or not, Dr. Ambedkar raised an objection. He said that listen, the Indian constitution is not a result of an agreement between states. It is a result of the freedom struggle, and the Constituent Assembly does not owe any mandatory right to the states. Okay, states are only for administrative convenience. Okay, so the constitution is not out of any treaty or agreement. states are for administrative convenience. That is why in India, by Article 3, the Parliament can amend or destroy an entire state. Okay, that for example, you can remove an entire state, split a state into two parts. Andhra was divided into Telangana and Andhra. UP was split. Multiple reorganization of states has happened in the past. Because ultimately states are for administrative convenience. You cannot do that in USA. In USA, a state is a state and they stay there for as long as they are a part of the agreement. Even in USA, they do not have the official right to secede, but back then, when the constitution was being formed, this was still debatable. Dr. Ambedkar clearly said in India, states have no right to secede. Okay, this was also to curb, because we were a very new nation. There were multiple parts of the country in the late 1940s which wanted to be independent. There were multiple princely states which wanted that somehow we can still drive a force and declare independence, because India was a very new country. So Dr. Ambedkar made it very clear that in India the states have no right to secede. Secede. Secede means to break away from an existing sovereign part. So cede means to part with sovereign territory. Secede means to part on your own. So basically, when any unit declares its own independence, it's called secession. Okay, you will discuss all of this in depth in the international law portion only. So this was Dr. Ambedkar's objection, that since constitution is not out of any treaty or agreement, and because states are only for administrative convenience, therefore you will not have the word called federalism. Simultaneously, he also said that there are two parts to any federal scheme which matter, and that is division of powers within the constitution and second, supremacy of the constitutional judiciary to resolve those disputes. Okay, so basically the states get their powers from the constitution. They are not dependent upon the union to grant them any powers. All right, the union cannot even amend the 7th schedule directly. कि अगर parliament चाहता भी है, so for any we will discuss this in amendment वाला class properly, but even if the parliament wants, it cannot amend the 7th schedule without consent of most of the states. So the division of powers within the constitution is within the constitution. The states are not dependent upon the union, and there is a supreme independent judiciary that will grant them those rights. So as a consequence, the functional parts of federalism are there, but the word was not used because we did not want the small technical issues that come with the use of word federal. All right, as a consequence, across various movements that were happening, there was a demand for greater devolution of powers, but never a demand for secession which was valid. Otherwise, if India was a federal country, the parts could have differently raised their argument that look, the Constituent Assembly also acknowledged. They never acknowledged because Dr. Ambedkar's view was final. All right. So let us discuss the federal as well as the unitary features in the Constitution, because the Constitution is not completely federal. There are multiple deviances from what the other federations of the world had. Our Indian Constitution is unique in that way. Okay, there are federal features such as written constitution, which is supreme. The amendment procedure is partially rigid. that any part that affects the federal scheme, such as the 7th schedule, which provides for the legislative lists, that cannot be amended without consent of the states. The procedure for amendment itself cannot be amended without consent of the states, etc., etc. So, a rigid amendment procedure is very important to preserve federalism. Otherwise, if it's a very liberal federal provision, then the union is unrestricted. In fact, very recently, the Supreme Court struck down the 97th Amendment in Rajendra and Shah. Rajendra and Shah versus Union of India. The Supreme Court struck down the 97th Amendment. Okay, this was regarding the cooperative societies. Now, cooperative societies are in the state list. The Union passed a constitutional amendment on how elections for cooperative societies should happen, etc. Multiple provisions on what should be the composition of board. The Supreme Court said this will only be applicable for multi-state cooperative societies because that lies within the union government's domain. But for all other cooperative societies at the state level only, they struck it down. In this case, Rajendra and Shah 2021. Okay. So this is one example that you cannot amend the constitution. This was added, 97th Amendment added part 9b into the constitution. You cannot amend the constitution which has state list subjects involved without consent of the states, because the consent of the states was not taken in this amendment. The entire amendment was struck down. Then we come to the next part. There is a bicameral central legislature, that the states have a right to send their representatives into the parliament. The Rajya Sabha provides for bicameral house, the upper house of parliament, and we have an empowered independent judiciary. Okay, so all of these are federal features. We have a much bigger list of unitary features, because ultimately in the Indian context it was always desired that to prevent different units from exercising too much influence, so much that they try to part away, the union should have a control over the major subjects. As a consequence, there is a union list dominance. Most subjects such as banking, finance, major infrastructure and industries, all of these, currency, all of this falls in the union list. We have a single constitution. There is only one constitution for the whole of India. Earlier, Article 370 gave certain powers to the Kashmir, the J&K region, but now that has also been taken away. So we have only one constitution for the entire country. In India, in USA, there is one constitution for America, and there are 50 constitutions for the states. So they have a total of 51 constitutions. While the American constitution is very small, but to understand American constitutional law, you will also need to know the entire law of the state, how they operate, how they function. India does not have any such system. India is very clear that we will have only one constitution. So that is a unitary feature that was meant to involve, to mold us into one nation. Alright, Dr. Ambedkar also said that ultimately all citizens are only citizens of India, that they may be residents of states, different states, but because states are only for administrative convenience, everyone is only an Indian at the end. Alteration, destruction of states is a power. We saw the Babulal Parathe case, that these alteration, destruction of states is a power with the union parliament, that there is no, the states do not have a right to object mandatorily. The parliament does not need the consent of the states, they only need the opinion of the states. Then we have the All India services, the IAS, IPS, forest, etc. All of these are services which are recruited at the union level. Their ultimate control lies with the union home ministry for IPS, forest ministry, environment ministry for forest service, and department of personnel for IAS, and they serve at the state level. So the district magistrate, superintendent of police, all of these are positions in the state government, but their ultimate control lies with the union. So all India services is a union feature, unitary feature. We saw that we borrowed governor's role from the Canadian constitution, that it is appointed by the union. The state government cannot elect its own governor. In USA they elect it. Other institutions such as Controller, Auditor General, Election Commission, Finance Commission, they are the same for all states. Alright, the Finance Commission gives the formula for devolution of central and state level division of finances for everyone. Election Commission conducts both state elections as well as central Lok Sabha elections. The CAG audits all the states as well as the union. We have emergency provisions wherein the state suddenly becomes unitary. Okay, whenever there is a national emergency in Article 352, basically we will discuss this in details, but in the emergency provisions class, but basically the state structure itself becomes unitary. In Article 356, there is President's rule and the state government can be dismissed. The parliament can take over the functions of the state legislature. So all of these are unitary provisions. Then there is financial dominance of the center. In Article 292 and 293, the states need consent of the center to borrow any additional money. That all of their borrowing capacity is defined by the center. Alright. So the center can set conditions that make certain reforms in your government, only then will you get more loans, etc. etc. तो इस तरीके से there is financial dominance of the center. Most of the taxes, income tax comes to the center. There is no income tax at the state level. Now we even have GST, which is also cumulatively decided. So there are a lot of unitary features in the constitution. Alright. This is why there are multiple comments on what is the nature of Indian federalism. Okay. We will discuss many of these. First is Professor Madhav Khosla. He is the chief editor of the Oxford Handbook. Oxford Handbook of Indian Constitution. In his book Introduction to Indian Constitutional Law, he calls the Indian federalism asymmetric federalism. Why is it asymmetric federalism? What does asymmetric federalism here mean? It means between states there is asymmetry. There are tribal states which have separate powers in 6th schedule. There are special status states. Etc. All states are not equal. In fact, for example, in USA, every state has equal representation in the Senate. Alright, the upper house of the US Constitution is Senate, which is similar to Rajya Sabha, but there every state sends 2 representatives and a 100-member Senate. In India, every state sends different number of Rajya Sabha representatives, okay, depending upon their population and other criteria. So, as a consequence, India is in asymmetric federalism as per Professor Madhav Khosla. Another name that you can use is Louis Dillon, who wrote an article called Asymmetric Federalism in the Oxford Handbook. Okay, so you can use that. Then we come to Sir Ivor Jennings. Ivor Jennings called India a federation with strong centralizing tendencies. Okay. Then we have Casey Ware, who called India a quasi-federal state. Both of these are very obvious. And then we have one important name, Justice Subbarau's dissent in state of West Bengal versus Union of India. This is also called the coal bearing areas case. Okay. So in this case, the Union government tried to take over certain territories for coal bearing within West Bengal. And West Bengal objected that you can't do this, land is a state subject, so you can't take over our land without our consent, that we are sovereign in that regard. The Supreme Court ultimately ruled that you can't do this. The objection is invalid. That ultimately the Parliament has the authority to take over the land. All right. Now, Justice Subbarao in his dissent laid down 4 cardinal principles of federalism within India. Okay. The first is contract or agreement between states to create a union. This is not present in India. Second is power of units. Units are states to alter the constitution. This is also not present in India. In India, the states cannot propose any amendment. In USA, they can. In India, only the Parliament has the power to amend. At most, if there is a need in Article 368, the states will have to give their consent to an amendment, but they will never have the power to amend the constitution. Okay. Third one is distribution of powers between units and center. This is present in India. And the last one is supreme judiciary. To interpret the constitution. This is also present in India. Okay. So 2 out of 4 cardinal principles are not followed. Basically the first and second, that power of the states to alter the constitution and agreement of the states to form a union. This is not available in India. Therefore, India is not a completely federal country as per Justice Subbarao. Much later, in state of Rajasthan versus Union of India, there were questions of various natures, whether basically Rajasthan has certain powers towards their own state judiciary, etc. And Justice Beg, Chief Justice at the time, said India is more unitary than federal. All right, that ultimately that is the nature of India's federalism. All of these were up till 1977. Later on, the debate was settled in this case called SR Bommai versus Union of India. So this laid down federalism as a basic feature, okay, called it a part of basic structure that you cannot amend, okay. Prior to this, even prior to the Keshwanand Bharti case, Dieter Conrad was an American jurist. Conrad had given the interpretation that since Article 1 Clause 1 says that India is a union of states, it can never be India is only a union, or it can never be India is a state in itself, okay. That India will always be a union of states. So there are going to be multiple states within the Union of India, as a consequence, India will be a federal nation. There will never be the power to completely destroy all of the states. This definition was also accepted in the S.R. Bommai judgment. All right. So, in the S.R. Bommai case, basically, the central government, after the Babri Masjid demolition, had dismissed certain state government because they thought that they did not follow the policy of secularism that is enshrined in the constitution. Now, ultimately, and in 1994, these 9 judges, it was a very large bench. A 9-judge bench is not extremely common, and most of the 9-judge benches that have been constituted, most of them we will be discussing in the course of this constitutional law lectures. All right, because 9-judge benches were rarely constituted, and when they were constituted, they gave extremely important points. So 4 out of 6 opinions rendered in this, there were 6 opinions. Multiple judges normally concur with each other. So not every judge writes their judgment always. Okay, some judges just write an opinion together. So 4 out of 6 opinions in the judgment say that federalism is a part of the constitution. Okay, and 3 out of 6 say it is a part of the basic structure. However, majority judges basically say that federalism is a basic structure. Federalism is a part of the basic structure. All right. A little more details, if ever, although you will not be needing this for writing an answer, but ultimately, S.R. Bommai judgment also said that you cannot dismiss a state government, a president cannot dismiss state governments without any reasons. So arbitrariness, Article 14 was one of the primary reasons as well, but they did say that federalism is a part of basic structure, and that was one of the contributors to the ultimate judgment. Okay. Later on, in Kuldeep Nayyar versus Union of India, this was reiterated that federalism is a part of the basic structure. In this case, the domicile requirement was taken away. All right, by an amendment to the constitution, the domicile requirement for Rajya Sabha members. Rajya Sabha members are nominated from states. Different state governments nominate Rajya Sabha members. So this restriction that the Rajya Sabha nominee has to be domiciled within the state from which they are coming from, which they are being nominated from, that was taken away. As a consequence, you will see Dr. Manmohan Singh, who was a Rajya Sabha member, was a Rajya Sabha member from Assam, although he did not live in Assam. So this was taken away. That was challenged, that this is against the idea of federalism, because then you can impose anyone from any state. The Supreme Court said that ultimately it will still be the state governments which are nominating Rajya Sabha members. So therefore it is not going to be a part of the federal, it is not going to violate the federal structure, and federalism continues to remain a basic feature of the constitution. That is what they said in Kuldeep Nayyar case. Okay, so these are the 2 basic cases. Both of them give in some way to Dieter Conrad, that you cannot take away the union of states, that states are a part of the identity of India itself. Normally, you will see that there are 2 kinds of federalism which are laid down: competitive federalism and cooperative federalism. Okay, we will see how India follows both. Okay. Cooperative federalism is where the center and states share a horizontal relationship and cooperate in public interest. Okay. Horizontal relationship, although center is above the states, it's a level above, but when it comes to welfare delivery, both center and state participate together. For example, we have the centrally sponsored schemes where for the same scheme 60% finance comes from the center, 40% comes from the state. Okay, and both of them act together to ensure that uh, public welfare is not hindered. States are participants in formulation of larger national policy. For example, in the Rajya Sabha, in Niti Aayog Governing Council, all state chief ministers are involved. In GST Council, the finance ministers of every state are proper members of the GST Council. So therefore, states also cooperate with the center in national level policy. And lastly, states and center must cooperate on executive matters by mutual delegation of subjects and on subjects in Schedule 7. We will discuss in article when we discuss the administrative relations between center and states uh, that there is mutual delegation which is permissible within the constitution itself. Okay, article 256, 257, 258, they give specific powers to the states. So therefore, there is cooperative federalism in India. Similarly, we also have competitive federalism. Competitive federalism is where states and centers share a vertical relationship and states inter se have a horizontal relationship. So there is one center and there is multiple states competing. Okay. States compete for scarce resources for development against other states by way of greater share in tax devolution by finance commission. Okay, finance commission lays down criteria that on so and so metrics you will have to devolve the share of central taxes to the states. For example, this year the finance commission gave 2.5% weightage to demographic effort. Now, states which have succeeded in controlling their demographic levels, they will benefit from this much more than the states which have not yet taken enough steps. So this is how states compete, that if there are criteria on which you can compete, there are ease of doing business rankings, there are environment rankings, etc., etc. Now the Niti Aayog makes so many rankings that states have a constant competition on who is doing better on what level, and then the states also use that. They use that their successes to say that listen, we succeeded, we did this, we did that, and the government of India has also acknowledged that we did it. So states also compete with other states for investors, better industries, as well as national level projects, major dams, major investments, etc. Everyone holds an investment summit these days. Lastly, there is promotion of healthy competition among states through various measures such as indexes by Niti Aayog, state performance, as well as through finance commission criteria. Okay, so this is competitive federalism. There is one quote that you can use in your conclusions, especially on a question on federalism, that it is desirable to have some friction, some amount of state contestation, and some deliberation generating froth in our democratic system. Okay, whenever states continue to demand certain things, the center also listens. Okay, it's not always that the unitary system keeps benefiting only the center, because the center is also a sum of its parts, right? A union is basically made of the states. So as a consequence, they listen to the states. And there are multiple committees which were formed by the states. For example, the Rajamannar committee, the Anandpur Sahib resolution, This was by the Tamil Nadu government once upon a time. This was in Punjab. All of these demanded more federalism, and consequently this back and forth continues to go on. Okay, so that is why Justice Chandrachud, who is the Chief Justice of India, he said in this GST Council case, Mohit Minerals versus Union of India 2022, that it is desirable to have some level of deliberation, contestation, and friction between center and states in a federal country like ours. Okay, that furthers democracy because everyone has the right to speak and every opinion gets some weightage. Okay, so let us move on to the next topic, that is secularism. Okay, secularism has multiple definitions depending upon who you ask, but effectively it is not theocratic state. Okay, a theocratic state is ruled by religion. For example, Vatican City or the Islamic Emirate of Afghanistan, etc. All of these are theocratic states. They follow one religion as their particular guiding ideology. A state that is not theocratic can call itself secular. The origin theory of secularism, this was in a lecture by Dr. Venkat Ramani, the Attorney General, that secularism originally came from the Mongol rule. If you study for UPSC in the history syllabus, the Mongols under Genghis Khan and other Kublai Khan, etc., they started this idea of secularism. Why? Because the Mongols were nomads. Okay, they did not have any one religion of their own. So Genghis Khan was scared to offend anyone's god. They were conquering vast areas of lands. Okay, they conquered the entirety of Asia from Hungary in Europe to the coast of China. They were conquering everything, and people had different religions. They did not care about the religion, they only wanted the power to rule. So, and they also did not want to offend anyone's god. As a consequence, they came up with this policy that we will not interfere in religion. Okay. Now in the 17th century, in 1600s, there was a book about how the Mongol rule followed this policy of separation of church and state, separation of religion from state. This really inspired in the 1600s and 1700s, this really inspired the American jurists, Benjamin Franklin, Thomas Jefferson, etc. The founding fathers of the US Constitution were very inspired by this theory of separation of religion and state. So they followed the idea of secularism to its modern form, that in the Constitution itself they were secular. Alright. At that time, none of the other European states were secular. Okay. In fact, even today, the Church of England has the crown as its head. That was in their history, and that was the reason why Protestant religion started, and the Church of England was separated because they did not want the Vatican to have so much control. But even today, there is a separate model. The secularism has different models. There is a famous Western model which is called the non-establishment clause, which is separation of church and state. That religion will not interfere in the affairs of state, state will not interfere in the affairs of religion. Okay, both of them are in separate domains completely. Then comes the French model. This is called laïcité. Laïcité is a innovative model, French innovation, which says no public display of religion. You have to be French in your character, not religious in your character. Therefore, they have imposed the hijab ban on women. No government functionary is allowed to pray in public, etc., etc. So that is called French laïcité. That in public you cannot bring religion, privately you can practice any religion you want, that is allowed. Then in USSR, the Soviet Union, there was Marxist atheism, where Karl Marx, the founder of the communist philosophy, had said religion is the opium of masses. That basically religion is used as a tool to keep masses in control. जैसे अफीम जो ओपियम होता है, if you take it, you will basically fall asleep, you will be enchanted by it, you will not be able to do anything productive. So Marx said that religion is the opium of the masses, that it keeps people in check by preventing any revolutionary ideas, by ensuring that people don't protest too much. Okay. The Indian conditions were very different. India did not have a monotheistic religion like these Western countries had Christianity or Islam. India had a vastly Hindu majority country which has different branches and very vastly different traditions across these lands. So we could not come up with the idea of church because there is no Hindu church. Alright, there is no one organization like the Vatican which controls Hinduism the way Catholic Christians are controlled by the Vatican. So we could not have those forms. We could not prevent people from practicing their religions. There are people, for example, Sikhs have to wear their turban. Without that, their basic identity as a Sikh is incomplete. So we could not adopt French models. Marxist atheism was also not considered appropriate. Why divorce it? Because Indian conditions required a lot of religious interference. In fact, Dr. Ambedkar in the debate on freedom of religion, we will discuss most of secularism when we come to the freedom of religion. But Dr. Ambedkar said that religion covers in India everything from birth to the funeral pyre and afterwards. That even what happens to your afterlife is controlled by religion. So every part of your life, from your birth to your various ceremonies such as the Janeo ceremony or etc., etc., they are considered and they are controlled by religion. Up to your death, how you are buried or how your shroud is conducted, all of that is controlled by religion. So not everything needs to be a part of freedom of religion. Okay, the government should have the right to at least control something. So as a consequence, Indian secularism was evolved. Secularism in India was added to the preamble. The word secularism was added in the 42nd amendment. Okay, this was not in the original constitution. It was not in the original preamble. Alright, it was always in Article 25. We will just discuss it. It was always present, the word secular. Okay. The original preamble did not use secular. The use of God was proposed by H.V. Kamath in the Constituent Assembly. This was rejected. Alright. The Constituent Assembly said we do not want that the constitution comes from God or in the name of God. It comes from the people. We the people is the source of authority. So the use of God was rejected. The use of secular in the constituent in the preamble was also proposed by Brajeshwar Prasad. Okay. This was also rejected. Why? Dr. Ambedkar's view was that people should be free to define the nature of the polity that they live in. Okay, that there are certain fundamental rights that we can grant to the people, freedom of religion, protection to minorities, etc. Beyond that, he was against the use of the word socialist or secular, etc. within the preamble, because he said how the economic or the political dispensation will be ruling should be upon the people. That should not be defined in the constitution itself. As long as we are a sovereign democratic republic, it should be fine. So it was only in the 42nd amendment that the word secular was ultimately added. Before that, it was not. In article 25 to 28, there is freedom of religion which is provided. Okay. So article 25 provides for the freedom to practice and profess one's religion. Article 26 provides for the freedom to denominations, different sects to practice their own religion. Then article 27 and 28 protect citizens from payment of any tax for religion and from religious education in public institutions. Alright. So these are certain fundamental rights that give you freedom of religion. Article 25(2) also allows the state to regulate any secular activity associated with religion. For example, if you have to take out a procession, आपको कोई जत्था निकालनी है, कोई celebrate करना है festival, तो the state can regulate how you celebrate the festival. The state cannot regulate the existence of the festival, पर कैसे मनाओगे? For example, you are not allowed to fire guns in a wedding, alright, even though you might consider that it's a part of your honor tradition or something, but you're not allowed that because the state has restrictions. So the state is allowed to regulate any secular activity associated with religion. We will discuss this in depth when we discuss article 25. Right now I'm just giving an overview. Alright. So there are certain views of how Indian secularism has been shaped. So I am giving you 5 of these biggest opinions that you can use. The first is by Pandit Nehru, Jawaharlal Nehru, that religion, secularism is a free play for all religions in India. Okay. Subject to not interfering with other religions or the state. So you have complete freedom for what you want to do, as long as you don't harm other religions and you don't obstruct the state from carrying out welfare. So you are free in your private domain to practice religion. The second one is by Rajiv Bhargava. All of these are legal jurists, okay, and their views carry a lot of weight. He uses the word principal distance, okay, principal distance or सर्वधर्म संभाव, that we maintain a distance from religion on the basis of certain principles, that on these and these reasons we will not interfere, but when basic principles of religion are being violated, such as discrimination of women, so for example in the Shaira Bano case, the triple talaq matter, even though it was held that it can be a part of your religion, but it will not be allowed because it is unconstitutional. Okay, so on those grounds there is a principal distance that the state maintains. Then we have Professor Upendra Bakshi. He is one of the most celebrated constitutional jurists of the 20th century. He uses the word rights oriented secularism and governance oriented secularism. Both are present in India. Okay, so rights oriented secularism is that the state will not interfere in your original religion. So in UK, for example, there is rights oriented secularism. In France, there is no rights oriented secularism. The state has the power to directly impose bans on your practice of religion. On the other hand, there is governance oriented secularism. that the state will not endorse, or in policies of the state you will not have religion. Okay. For example, in election campaigning, you cannot use religion. The state cannot invoke religion of any sorts. So that is called governance oriented secularism. That is also present in India. This is also present in France, but this is not present in UK. In UK, the Church of England, etc., all of these religious matters are in some way related to the state. So there are rights of the citizens, and now the Church of England is not very important as an institution, but it still exists. So governance oriented secularism is not so much directly present. A similar example is Turkey, where the state controls all the mosques of the country. So even though people have the right to follow or not follow religion, but the state will continue to have that religion. Okay, so different models of secularism exist in India. Both rights based and governance oriented secularism exist. Then we have Dr. Rajiv Dhawan. Rajiv Dhawan lays down 3 parts of Indian secularism. Okay, first is religious freedom, second is celebratory neutrality, that everyone is allowed to celebrate subject to public order, that is all, and the last is reformatory justice, that the state will step in to regulate and to reform, that is not a restriction. And we have constantly done it in the past, that there were the Hindu code bills, even now there are talks of the uniform civil code. So all of this continues, that reformatory justice is a part of Indian secularism. The final quote is by K.M. Munshi. In the Constituent Assembly, he made this speech where he said that the non-establishment clause of the United States was inappropriate to Indian conditions. The non-establishment clause was inappropriate to Indian conditions, and we had to evolve a characteristically Indian secularism. That this was something that we evolved on the basis of what we required. We did not borrow it from anywhere. Okay. So these are certain views on what Indian secularism is. There is one good quote that you can quote. Our tradition teaches us tolerance, our philosophy preaches tolerance, and our constitution practices tolerance. Okay. O. Chinnappa Reddy in Bijo Emmanuel versus State of Kerala. We will discuss these cases in the freedom of religion classes. Okay. Now we come to constitutional conventions. These are uncodified practices giving form to specific aspects laid down in the constitution. So sometimes the outcome is laid down in the constitution, but the procedure on how do you get there is not laid down in the constitution. So those are followed by constitutional conventions. The rationale for this is that it allows flexibility with changing times. Okay, at some time there is a convention that you must do this to achieve that outcome. If, for example, technology comes into being or times change, then new conventions might evolve. Okay, this allows flexibility and discretion of the political executive during uncertain times. For example, in the COVID-19 pandemic, Parliament had an online session initially. So all of that was possible only because we have certain traditions of conventions. Ultimately, that did not take shape because a one-day session ultimately was held, but effectively the discretion of political executive allows for this flexibility. Okay. This is different from parliamentary conventions, 0 hour or business and transaction of business rules, etc., etc., starred questions, unstarred questions, all of these are parliamentary conventions, the role of the speaker. This is different from constitutional conventions altogether. Okay. What is a test of constitutional convention? How do we see if something is a constitutional convention or not? Sir Ivor Jennings has laid down a 3-stage test. First is there precedent? Okay, has this happened in the past? If it has happened in the past, then you see, why did it happen in the past? Were the actors believing that they are obligated to do this? If actors believe that it is their obligation, okay, that it is binding to do it, then it's a convention. After this, you have the need for a good reason. Okay, if people were doing something in the past with the belief that it is binding and there are good reasons for it, then it is a convention. Okay, so in the past, if there is precedent without reason, Sir Ivor Jennings says that in the past, if there is precedent without good reason, then it is merely a tradition. Okay, merely tradition that can be done away with. Someday someone will say ki why should we do this? We should not do it. But if there is good reason to do something, then even if it has been done only once, even if something has happened only once in the past, but with good reason to do it because the actors believed that it was binding, then suddenly it becomes a convention. Okay. So there are basically a few examples. There are not many noted constitutional conventions because in India we have one of the bulkiest constitutions in the world. So most of the details of administration have been written down in the constitution itself. In UK, for example, they depend a lot more on convention. In India, we don't do so much anymore. So a few very minute conventions which at times took up a lot of space is firstly the president's appointment of prime minister in times of unclear majority. To prevent a hung house, the president has to appoint a prime minister. If no party is in majority, then who to appoint? So they have taken different steps. They have taken coalition leaders, they have taken majority, largest party, etc., etc. Different presidents have taken different approaches and all of them are valid. We will see this in the next class when we discuss powers of the president. Okay, that this is a presidential discretion ultimately. The next is president's dissolution of house after the PM loses majority, because once the PM loses majority, the president should not be acting only on the aid and advice. Okay, for most of the part, the vast majority of cases, the president is bound by the aid and advice of the prime minister. But dissolution of house is one such instance, at present the only such instance as of now, where the president does not need the advice of the prime minister to dissolve the house, although they should wait for that advice. Okay, we will discuss this in the next class, that in Shamsher Singh case it was basically said that you wait for it, but ultimately you will have to dissolve the house if the PM loses majority and there is no other PM. Then comes dismissal of state government that has lost majority. That is also example of a constitutional convention, that you must do it, you should do it until unless there is an alternate government ready, that a house that has lost majority should not be continuing. It also comes from the part that the oath of the president is to protect, preserve and defend the constitution. A part of the oath. We will discuss the full oath, etc., all of this in the next class. Okay, but these are some conventions which are followed only to give shape, because Article 75 says that Prime Minister will be appointed by the President. Who will be appointed? At times it's unclear, so President has to come up with a convention. Alright. Now what is constitutional morality? While constitutionalism signifies politics of restraint, that there will be limited government, constitutional morality is a set of conditions and practices that agents of a constitutional setting must subscribe to. Agents of a constitutional setting are basically the governor, CM, PM, governor, etc. Okay. So there are multiple such constitutional settings and conditions. It need not even be a democracy. Okay. Most constitutional settings are democracies, but even for a constitutional monarchy, even for any other constitutional autocracy, as long as the agents of that constitutional setting follow the core principles of that constitution, that is called constitutional morality. It is the morality of that constitution, such as honoring court verdicts. If the government does not follow the court verdicts, then there is going to be an issue. If governments abuse powers, then ultimately, if for example they rig elections, that is going to be an issue, all right, because then there is no free fair elections, then democracy will collapse. So governments have to restrain themselves in line with the ideals of the constitution. That is constitutional morality. They should appoint neutral functionaries. In the election commission case recently, Anup Baranwal, this was held that to have a neutral functionary is very important for a democracy. We will discuss specific examples later on, but the idea that the objectives of the constitution have to be met in a particular way by the people themselves, right? Because it is the spirit of constitutionalism that you need to restrain yourself. All of this comes, constitutionalism itself comes within constitutional morality. Okay, because that is the very opposite of a government limited by constitution needs to be limited by the constitution, right? In reality. So there is a very good debate, almost a speech by Dr. Ambedkar in the Constituent Assembly on what does constitutional morality really mean. Okay, so on 4th November 1948 in the Constituent Assembly, Dr. Ambedkar quoted this classical author, classicist George Grote, to elaborate on what is constitutional morality. Okay, so he said that in the 19th century, constitutional morality meant practices and conventions where constitution is silent, because constitutions were being written down. There were very less number of constitutions. So the constitutional silences had to be interpreted through constitutional morality. That is what the word meant. But as we grew, as time went forward, people realized that that is not simply what constitutional morality means. It is not simply the substantive morality of the constitution. Okay, it is not just having free and fair elections. It is not just having neutral appointments. It is not just honoring court verdicts. Okay, the aim of constitutional morality is to avoid revolution by resolving disputes through constitutional means. Okay, so basically the idea was that we as a country emerged as an independent nation because we were fighting against someone. The Indian freedom struggle rose against the British colonial power primarily because Britain did not want to resolve disputes with Indians as equals. They did not give the appropriate amount of dignity to Indian leaders. They wanted the control for themselves, and as a consequence, Indians rose in protest. Indians ultimately revolted against the British. They disrecognized the government as legitimate, even though that was also a government once upon a time, the British government of India. So the idea is that once you have a constitution, people are still going to have disputes, but you need to resolve those disputes by constitutional means. And unless you are able to do that, you will not have constitutional morality, because if there is discontent in the people, that we will have, that they are being heard, that they are being listened to, they will ultimately end up rising against the government. Okay, we have multiple cases where we succeeded in resolving those disputes. Many insurgencies in the northeast, in many Naxal areas, people have surrendered because they ultimately believed that they were being heard, that the state also takes care of them. And for example, very recently, a few years ago, there were the Bodoland Accords. So the Bodo insurgency, which wanted separate powers for themselves, they felt that earlier they were not being recognized. They gave up arms. They gave up their struggle. They became a part of the, started taking pride in being citizens of India. So this is recognizing pluralism in the deepest way, that you acknowledge people as human beings who want to be ultimately acknowledged as who they are, and to make them a part of your system. So this is what Dr. Ambedkar said, that constitutional morality, the reason why we have a constitution is so that someday another revolution is not necessary, that you can ensure ultimately that people can all take pride and be a part of India as we know it. So these are some of the salient features of the Indian Constitution, and from the next class onwards we will be discussing separate parts. Okay, thank you.